Hello there. So welcome to the recording of our high cost webinar in relation to sort of counsel fees within high cost family cases. What we're going to be going through in this webinar is sort of an introduction to say what the reasoning around this was, along with covering our single counsel case plans, our CCFS, and our King's Counsel CCFS cases. We'll then move on to our hourly rates and appeals costs for counsel, and then talk about the FGF equivalency fee that we use in two counsel cases. After this, we'll then move on to billing to finalise the presentation. So the purpose of this webinar is to go through and to give you an understanding of the high cost family process, including single and King's Counsel cases, hourly rates used within high cost cases, as along with our FGF scheme that is used in two counsel cases. And we'll also cover any sort of related counsel billing issues that you might encounter when dealing with high cost or complex work streams. The first section that we are looking to cover will be the single counsel case plans. And the first thing I would like to do is give you an overview of how a single counsel case plan under CCFS works. So when a case is registered as high cost, this is when the solicitor anticipates cost will exceed £25,000. And this is based on when counsel fees are at FAS fees, not when they are claiming events. Once a case has been registered, we will set up a case plan task for the solicitor, and then they will be given the option to submit a high cost contract and to increase their cost limit to £32,500. You should consider at this point whether your fees will escape FAS and be submitted under CCFS, but you should also keep all necessary supporting documents just in case there's a change in the fee scheme later on where you go from being CCFS to FAS, depending on how the case progresses. Once the case has been registered and the limit has been increased to £32,500, this will enable counsel to continue submitting their FAS fees, or if counsel is claiming CCFS, 100% payments on account for those rates. If the costs in a case are projected to exceed £32,500, the solicitor can at this point opt to submit an interim case plan. An interim case plan is a light touch assessment where we don't ask for all supporting documents on the case, and the idea is for us to be able to increase the limit further to allow the continued claiming of payments on account on the case. Once the case concludes, we would then expect the provider within 3 months to submit their final case plan, including all supporting documents. For counsel, this would be any sort of endorsed brief back sheets, your CAF forms if you haven't already provided them. And this is at this point where we'll do an in-depth review of the case to agree the final cost so payment can be made. In relation to counsel, one of the most important things to consider is the number of main hearings, because this will indicate whether counsel remains at FAS or whether they can claim the CCFS events model. And this is based on whether a case exceeds 10 main hearing days. A main hearing day is defined as a hearing listed for and proceeding as a substantive fact finding or final hearing, and any separate judgment day following those hearings. This does not include IRHs. Counsel may opt to claim CCFS where the number of main hearings has exceeded 10 days, but they also don't have to if they don't wish. They can continue to remain at FAS. The calculation is based on actual previous sitting days at the point that the case was registered and all future listing days post-registration. If the case changes as the case progresses, the number of main hearings is simply adjusted up or down, which may result in fees returning to FAS. To give you an example of this, if there was a 5-day listed hearing prior to registration, but only 3 days sat, this would only be 3 days. However, in post-contract, if it was a listed hearing for 5 days and the hearing then only proceeded to 2 days and it was reduced within 5 working days, there would be 2 underruns claimable, but the 5 days would count as the total number towards the main hearing days. It's also worth remembering that reading days do not count towards main hearing as a hearing day unless the advocates are put on notice and are required to attend court on that day. Written submission days do not count towards the number of main hearing days, other than in circumstances where an underrun would be applicable. So an example of this would be if you have a 10-day listed hearing, and during the hearing, day 9 was set aside for the preparing of written submissions, an underrun would be claimable for one person, and the person who prepared the written submissions would get a full event. Because this was listed as a sitting day, as a hearing that was going to take place, this is why it would count towards main hearings. If in the same scenario, a hearing is listed for 10 days, but in the listing it specifically states day 9 would be for written submissions, this would not count. It needs to be recognised that preparation is front-loaded, and therefore if a main hearing underruns or overruns, the agreed price is adjusted by the refresher rate. Underruns and overrun event rates will only apply to hearings post-registration. And top tip is to bear in mind that where a hearing is vacated and further days added, underruns are not claimable, and the preparation is considered as the preparation is not considered wasted, and full events would be listed claimable in the relisted dates. So common issues that you may find when dealing with single counsel events cases are often around the court orders for advocacy meetings, or advocacy meetings being ordered retrospectively. It is important when claiming CCFS within the rules that all advocacy meetings must be ordered in advance. So the court orders need to be provided to us when the final submission is sent. Another common issue that we have is that we don't receive the endorsed brief back sheets for advocacy meetings and conferences from counsel when the final case plan is submitted. So it's important that you provide those to your instructing solicitor. So a top tip for those is that we don't need separate endorsed briefs for all advocacy meetings and conferences. We would accept one endorsed brief detailing out all advocacy meetings and conferences, which is signed by counsel. Another common issue we have is court orders not being provided for main hearings. As I said, this is more in the domain of the solicitor to provide these information, but it is helpful if you have them to make sure that you provide them to the solicitor so they're aware of what the current listings are for when they come to their final case plan. Court orders which have been done via consent where a hearing has not taken place do not attract an event fee, and they are remunerated within the overall event price. So they should not be claimed within a CCFS case plan. We do often have issues in terms of disbursement vouchers not being included. For counsel, this is often your travel and hotel costs. So it is important that you provide those to your instructing solicitor. In relation to counsel, if travel is being sought, we may often seek justification from your instructing solicitor for why a more local counsel is not being used. So you may wish to challenge them on this when you take the instruction. As mentioned in the previous slide, underruns and overruns are occasionally claimed incorrectly. You need to remember that this only affects post-contract costs in single counsel cases, and the listing is based off what was made up to 5 days prior to the hearing taking place. If the listing is changed within 5 days of the hearing taking place, this is when underruns and overruns would be claimable, depending on what happens to the hearing. We often find that CAF forms are not provided to solicitor, and we have to chase these when the final submission comes in. I would recommend that you provide those to your instructing solicitor as soon as possible so they can be added to the case plan task while we deal with the costs. What I'm going to do now is I'm going to pass you over to Stuart Allen, who's going to go over the two counsel events model.
Thank you, John. So my name's Stuart Allen and I work on the High Cost Family team. So I will be taking you through the King's Counsel or two counsel CCFS model. So for a King's Counsel case or a case with authority for two advocates, the case will be registered as high cost from the date that prior authority is granted so that prior authority could be granted for either King's Counsel alone, King's Counsel and Junior Counsel, or two Junior Counsel. It's worth noting, however, that we won't automatically register a case as high cost in circumstances where the authority granted is only for a discrete element of work, such as advice or an appeal hearing. So when prior authority is being granted and you're instructed by the solicitor, it's really important that you seek confirmation from the provider of the exact terms of the prior authority granted. So the prior authority granted will have specific terms. A common one is often that it's granted up to and including a fact-finding or composite hearing. So it's really important that you get confirmation from the provider as to the exact scope of this authority. If they are to just provide you with a copy of the certificate, for example, this doesn't actually include the specific terms of that authority. So you should consider which fee scheme is going to be applicable and whether your fees will escape either FAS or the family graduated fee scheme equivalent, and ensure that any necessary support and documents are obtained for the applicable fee scheme. And it is also worth noting that depending on how a case runs, it may be that you were expecting it to be claimed under one fee scheme, and as the case progresses, it turns out that a different fee scheme is applicable. So it's really important that you ensure that you do have all of the relevant necessary support and documents. So when the case is registered as high cost, the provider should provide to us their signed contract, and then they can submit a cost amendment for £60,000. This enables costs to be allocated for either payment of FAS fees or 100% payments on account if either CCFS or FGF is applicable. So if costs above £60,000 are going to be required whilst the case is ongoing, then the provider should submit an interim CCFS form. There is, however, no requirement for them to do that whilst the case is ongoing. So if costs are going to exceed £60,000 and you would like the provider to increase the cost limit to enable payments on account to be made, you need to be liaising with the instructing solicitor to ask them to submit an interim CCFS form. For interim CCFS forms, we will just complete a light touch assessment. So it's generally just the CCFS form that would be considered, and we don't require any supporting documents unless specifically requested at that stage. It's at the conclusion of the case that we will then require a final CCFS form, and that should be accompanied by all supporting documents for a full final assessment to be undertaken. So one important consideration is how to calculate the number of main hearings to determine which fee scheme is applicable, or and whether or not you are eligible to claim under CCFS, or whether it would be at FGF or FAS, which junior counsel may opt to remain at. So a main hearing is defined as a hearing listed for and proceeding as a substantive fact-finding or final hearing, and any separate judgment following on from those hearings, and this does exclude an issues resolution hearing. Counsel should claim CCFS where the number of hearing days exceeds 10 days, and this calculation is based on the listings of the main hearings in the case throughout the lifetime of the case, and this will include both claimable underruns and overruns. So this is slightly different to the single counsel model, which John has just ran through, where we apply both underruns and overruns throughout the lifetime of the case, and both a claimable underrun and a claimable overrun will count towards the number when determining whether or not counsel is eligible to claim CCFS. Similar to the single counsel model, reading days don't count towards the number of main hearing days, other than in circumstances where the advocates have been put on notice to and are then actually required to attend court for a hearing that day. Written submissions don't count towards the number of main hearing days, other than in circumstances in which an underrun is due for the other representatives. And it's recognised that preparation is front-loaded, therefore, for main hearing underruns or overruns, then the agreed price is adjusted by an overrun or an underrun fee. And it's worth noting that where days are vacated and then further days are subsequently added, underruns are not claimable, as that preparation isn't considered wasted and full events are paid at the relisted date. So common issues that we come across under the King's Counsel or two counsel model. Often we see that too many either conferences or advocates meetings are claimed. So the rules under this model are that there is a limit of 2 conferences and 2 advocates meetings throughout the case. If, however, the main hearing is split so that there is a separate fact-finding and then a separate final hearing, then up to an additional 2 conferences and 2 advocates meetings may be claimed in the welfare stage. Now, this limit would apply to each grade of counsel. So in circumstances where we've granted authority for King's Counsel and Junior Counsel, King's Counsel would be entitled to 2 conferences and 2 advocates meetings, and Junior Counsel would also be entitled to the 2 conferences and 2 advocates meetings, again with an additional 2 conferences and advocates meeting being claimed and being applicable in the welfare stage if the main hearing is split. In circumstances where we've granted authority for 2 junior counsel, then the person who undertakes the role of the first junior counsel will be entitled to 2 of each, and the person who undertakes the role of second junior counsel will also be entitled to 2 of each. Another common issue is the lack of supporting documents for advocates meetings or conferences. So it's really important to ensure that endorsed brief backsheets are provided for these. And similar to what John explained for the single counsel model, we will accept one sheet listing all of them that has been signed by counsel to confirm their attendance at all of those dates. Written submissions is a common issue under this model, and this is only claimable where a hearing has been listed in excess of 10 days, and then partway through that listing, one of those days is subsequently set aside for the preparation of written submissions. Only in that scenario is the advocate who prepared them eligible to claim one event, and the other representatives will then be due an underrun. So to give you an example of this, it would only be claimable in circumstances where a hearing has been listed. So if I can give an example of a hearing being listed for 15 days, partway through that hearing, one of those days is then set aside for written submissions. In that scenario, it would be claimable. If, however, that hearing had only been listed for 10 days or less, and partway through one of those days was set aside for written submissions, an event for written submissions wouldn't be claimable because the hearing hadn't been listed in excess of 10 days. Again, if the day had been listed in advance for written submissions, that also wouldn't satisfy the criteria, as it is only where that day is set aside partway through the hearing for the written submissions. Another common issue that we come across is where claims are made by counsel for fees outside of the prior authority period. So, for example, where there's been authority granted for King's Counsel and Junior Counsel up to the end of a fact-finding hearing, occasionally we'll see it where King's Counsel is then claiming for events beyond that fact-finding hearing, which isn't covered by the prior authority, and those fees are not claimable. Another common issue is in relation to underruns and overruns, and it's just important to ensure that they are claimed correctly. And we do take the listing in the same way that we do under the single counsel cases, where we take the listing so that it's the most up-to-date listing with more than 5 working days notice prior to the day that the hearing was due to commence. As I'd mentioned on a previous slide, we do apply both underruns and overruns throughout the lifetime of the case, and not just from the date of registration, as it is applied under the single counsel model. Another common issue, as it is in the single counsel model, is where events are claimed in the absence of a hearing taking place where a consent order is drafted, so an event is not claimable under those circumstances. A common issue is missing counsel acceptance forms. So it's really important just to ensure that these are provided. They can be provided throughout the lifetime of the case, but they will be required before final costs can be agreed at the end of the case to enable bills to be paid. We will require justification for the use of non-local counsel, so the solicitor should be explaining to us why they haven't instructed counsel from a local chambers if they have instructed somebody further afield. And another common issue where travel or other expenses are claimed is that those vouchers are missing, so it's important that these are provided. I'll just hand you back over to John now, who's going to cover the hourly rates.
Thank you for that, Stuart. So what we'll be discussing now is hourly rates being claimed in high cost cases and how this works for counsel. Where there are no prescribed rates under the high cost contract, there is significant amount of discretion in dealing with the rates that are applied. For those cases where proceedings are excluded from FAS, what is the appropriate rate to pay may entail having regards to the solicitor's rates, FGF rates, or what is reasonable. Reasonableness will be determined by the facts of the case. Solicitors' harmonized rates are claimable for proceedings arising from separate representation of a child in private law proceedings. It is important that during these cases that you are entitled to enhancement like solicitors, and that when you submit your fees that you provide any justification for enhancement that you're wishing to claim. For single counsel cases where wardship and inherent jurisdiction proceedings, the applicable rate for counsel will be either £112.50 or £135, and that is depending on the year of call for counsel. In relation to appeals and appeals to the Supreme Court, there are different rates that apply. So for appeals of an interim hearing, a scope amendment isn't required by the solicitor. However, if in those appeals they're seeking the use of King's Counsel or multiple counsel, a separate prior authority will need to be submitted by the solicitor for this. In the same way as Stuart has mentioned previously, it is really important that you get copies of what is being granted for in relation to the prior authority, because it may not cover an appeal, or it may only cover a certain aspect of appeal, such as the skeleton argument. Payments to counsel in Supreme Court are paid on an hourly rate basis. Within the slides, you can see the rates that are claimable in relation to Court of Appeal and Supreme Court. So in the Court of Appeal, King's Counsel can claim £180 per hour. Leading Senior can claim £157.50. It is worth noting that leading senior is only claimable where authority has been granted for King's Counsel, yet a senior junior is taking on the responsibility and acting as in King's Counsel's place. Junior counsel rate would be £112.50 or £135 if it's a single counsel case, and a note taker pupil or a second lead junior would be £36 per hour. In Supreme Court, the rate is for King's Counsel is £225. A leading senior is £180 an hour, but as mentioned with the Court of Appeal, this is only claimable where authority has been granted for King's Counsel. A lead junior is £112.50, and junior counsel acting on their own, it will be based on the year of call of £112.50 or £135 an hour, and a note taker would be claimed at £36 an hour. When counsel fees are being claimed at hourly rates, it is really important that you provide justification for the costs that you're claiming. Submitting a case, if the solicitor submits a case plan and it literally states 10 hours for claiming a certain item of work, it may be that we come seeking further justification. So if you can break down your hours that you're claiming or provide justification for the hours, it would save further need for further assessment if we're unsure on what work is being undertaken. It is also worth noting that the Supreme Court, the maximum fees are set out in the practice direction, which is linked within the slide pack for this webinar. And this is the maximum that could be claimed. Costs will still need to be justified for the reasonable and proportionality of the costs. I'm now going to pass you over to Stuart again, who is going to go through the family graduated fee scheme.
Thank you, John. So yes, I'm going to cover the family graduate fee scheme, or the equivalent of the FGF scheme. So this scheme applies to family cases where there are less than 11 days of main hearing and prior authority has been granted for either King's Counsel and Junior Counsel, King's Counsel alone, or two Junior Counsel. This scheme will also cover cases regarding child abduction, FGM, and forced marriage, which may or may not have authority for King's Counsel or multiple advocates, so it would still apply for these cases where there's only single Junior Counsel authority. There are 4 categories of proceedings. There's Category 1 for family injunctions, Category 2 for public law children, Category 3 for private law children, and Category 4 for ancillary relief and all other family work. So Category 2 is the main category of work covered for high-cost family cases, and that's going to be the focal point of this section of the slides. And this is applicable for cases for care and supervision, wardship and inherent jurisdiction, and proceedings under child abduction. So the FGF scheme is broken down into a number of different functions. So function 1 relates to a drafting fee, such as for advice, and there is a limit of 2 claimable throughout the case. In circumstances where we've granted authority for 2 advocates, both of the advocates will be entitled to claim 2 F1 fees within the case. Function 2s, the F2s, are for injunction hearings. We don't see these very often. The likelihood is when we do come across these that they have been claimed incorrectly and a different function should actually be claimable. Now, function 3, this relates to interim hearings and advocates meetings. So with the function 3, this is actually built up in multiple function units. So the function units are built up in 2.5-hour units, and that is from either the time the hearing was listed to commence or the time that counsel was ordered by the judge to attend if they were required by the court to attend earlier than the hearing listed time. So it starts at that time and it's calculated in 2.5-hour units up until the time that the hearing concludes, or 5 p.m, whichever is the sooner, and you would subtract from that the lunch adjournment, which is generally an hour. Where a hearing runs beyond 5 p.m, and by working beyond 5 p.m, that hearing concludes, so there's no requirement to attend court the next day, then an additional half function unit is claimable. Function 4 is for conferences, and similar to the function 1s, there is a limit of 2 of those claimable throughout the entirety of the case, and where there's authority for 2 advocates, both of the advocates are entitled to claim up to 2 of those F4 conferences. This is slightly different to what I covered under the 2 counsel model in relation to the events model, where when there was a split main hearing, an additional 2 conferences became claimable. That's not the case under FGF, and there is just an outright limit of 2 F4s. Function 5 relates to main hearings, so that's going to be your fact-finding and final hearings. And there are 2 different functions available. So the first one is known as an F5 primary, and this is claimable for the first day of the main hearing, and only one is claimable throughout the entire case. In circumstances where there are 2 advocates, so for example, King's Counsel and Junior Counsel, both King's Counsel and Junior Counsel would be entitled to one F5 primary. All additional days of the main hearings are then claimable as an F5 secondary fee. And this fee, only one function fee is claimable, which covers the entirety of the day. So in the earlier functions, such as the function 3, both a function 3 and a function 4 can be claimed on the same day, but for function 5s, no no other functions can be claimed that day. The F5 is deemed to cover the entirety of the day. It's worth noting that the F5 primary may actually be claimed for either the pre-hearing review or the issues resolution hearing in circumstances where the same advocate then goes on to attend the main hearing, and then all subsequent days of that main hearing will be claimable at the F5 secondary rate. So each function is comprised of a base fee that can be increased by certain uplifts, such as core bundle payments. So core bundle payment 1 is applicable, where the core bundle is between 176 pages and 350, and core bundle 2 is applicable, where the core bundle is 351 or more pages. There are uplifts for SIPs or special issue payments, which we'll come on to the next slide. Additional fees can be claimed for special preparation, which is justified based on the complexity of the case and how additional preparation above that which would normally have been required for a case of this nature is undertaken. A 33% uplift is applicable for a time where the case is being heard by a judge of high court, judge level. And there's other incidental payments applicable, such as a case management conference bolt-on fee. So the SIPs are special issue payments that are applicable under category 2. SIP number 4 is applicable for more than one expert. So this is applicable where more than one expert is instructed, and this will relate to both the cross-examination of experts given evidence and or where expert reports are to be read. SIP number 5 is applicable where there's a relevant foreign element. So this is where the law of a foreign jurisdiction is of substance and relevant to any of the issues before the court. SIP number 7 for conduct issues is applicable where the case concerns conduct by virtue of which a child may have suffered or might suffer very significant harm. SIP number 8 is for where you act for either a parent or the perpetrator. So this is for representation of a parent of a child who's the subject of proceedings or another person against whom allegations have been made that he or she has caused or is likely to cause significant harm to a child. And SIP number 9 is applicable where the client has difficulty in giving instructions or understanding advice. And this is applicable where the person represented has difficulty giving instruction or understanding advice, which is attributable to a diagnosed mental disorder or a significant impairment of intelligence or social functioning. So the most common reasons for rejection under the FGF model are that no claim 5s have been provided. So it is really important that the claim 5s are provided to detail to us exactly how the fees claimed have been calculated. Another common issue is that a 10% reduction hasn't been applied so this is applicable for all certificates which have been issued after the 1st of February 2012. So the likelihood is that this 10% reduction should be applied. Another common issue is that special preparation hasn't been justified. So where special preparation is claimed, we do require justification. So that justification should explain to us whatever the complexities are which have led to the additional preparation. And it should break down to us the standard preparation, which would normally have been undertaken and is accounted for within the function fees paid, and then the additional preparation. And you should ensure that only the time above the normal preparation is claimed as special preparation. So this doesn't get applied to all preparation. It's only that over and above the standard amount, because the function fees that are paid, such as your function 3s or your function 5s, for example, they themselves do include the standard level of preparation within those. Another common issue is where the SIPs have not been justified. So it is a good tip to provide justification and explain to us how the SIPs are applicable. We will check the case narrative that's provided by the solicitor when they submit their case plan for us to try and work out how the slips are applicable. But if it's not clear from that, that can be a reason why we have to reject and get further information as to how those slips are applicable. And another issue is, as I've explained on an earlier slide, that the limit of 2 F4 conferences has been exceeded. So I will now hand you over.
So I'll pick up from slide 24. My name is John Bainbridge. I'm one of the senior caseworkers based in South Tyneside, and my specialty is the high cost billing. So we're going to run through some of the common issues to do with council billing today, and we'll get started here. So council claims should be paid or at least submitted before a solicitor's final bill submission, as we're unable to process solicitor final claims where council costs are outstanding. That's quite a big issue that we have. It is something that affects your instructing solicitors' final bill submissions and the ability for us to pay those. So it is really, really important that council claims do get in before the solicitor's final bill is paid as well, or at least at the same time. So all councils should claim their own fees where a cost allocation is made. There's no really reason why the solicitor should be claiming for a council. It is easier for yourselves to claim your own fees. And as I said, there's no real reason why the solicitor should be there to do that for you. And since 2023, February 2023, CCMS upgrade has allowed council to recoup their own POAs independently. You can do this as part of your submission process, or you can ask us to do that for you within the document submission process as well. And it has eased the requirement for submission at the same time as solicitors on the final claim. This is only applicable where we do hold a CAF or a BAF, as they used to be called, or the costs are agreed via a high cost contract, and it's not really applicable to general billing. So it is really quite important that you understand that as well, because if you do sort of submit prior to a solicitor in a general bill, the likelihood is that it would be rejected back to you. So the council cost allocation should match the high cost agreements, but where the council costs do not reconcile and there are insufficient costs available for solicitor's final bill, your claim will be rejected. So you need to really just make sure you do have sufficient allocation to be able to, for us to be able to pay the bills for you. So if council have claim in excess of their agreement, especially where there's FARs, we do recommend that you contact your instructing solicitor, who should be able to contact the high cost family team to have the agreement amended before resubmitting your final claim. This is something that they can do on high cost family. So we do recommend that you do contact various people, whether it's your instructing solicitor or the high cost family team themselves, where you know that something's going to be in excess of any agreement that you've already made. So that takes care of slide 24. So I'll pass you across to my colleague Brian for slide 25.
Hello, my name is Brian Chapman, and like John, my primary focus is high cost billing, has been for a number of years. So to cover off some further common billing issues, always attach all the relevant documents when submitting a claim, please, such as the fee note or CF1A, whichever may be applicable. And also please note where hotel, travel and subsistence costs are claimed, we need to see receipts for those particular items. This is the main cause for the rejection of council claims or the assessment or the assessment of these types of claims. Your claim will not be paid without them. Also, agreements made under the FGF scheme do not require a Claim 5 form on submission of the claim. You only need to submit a single line CCMS bill for all your costs, as the assessment is effectively for these types of claims done at the negotiation stage. We will accept summary level claims for council, however, these must be accompanied by a fee note, which should provide a breakdown of the amount that's being claimed. We will also accept a line-by-line claim on a CCMS submission without a fee note for CCFS claims. So for each other claim types, we need details on preparation and the disbursements being claimed. Hourly rates are pre-agreed in contracted matters and reconcile on bill processing to the agreed case plan in the matter. Pre-contract claims are solely assessed by the billing team, and the case manager will agree post-contract costs only. So just for confirmation, pre-contract claims are separate post-contract claims, and these are carried out by the billing team. Enhancement on pre-contract should be fully justified, and a single complexity narrative will not usually be sufficient to allow the claim to be processed. Pre-contract enhancement will generally be allowed at a rate harmonised with the post-contract agreement, and it will be highly unusual to allow a higher rate in the pre-contract stage. That is the end of slide 25. I'll now pass you across to John, who will now cover off slide 26.
Thanks, Brian. So one of the biggest problems that we have with council claims is travel. Probably you're already aware of this, but travel is claimable from the Chamber's address only. So if the council lives closer to the destination, they should be claiming that from the home address. You will need to provide the information to us upon billing. This can be part of your narrative, it can be on your CF1A, it can be on your fee note, but if you just give us the further information that we need to be able to justify your travel, then we should have no requirement for any further rejections or any further assessments on that one, to save everybody a bit of time. Train and car travel should be evidenced. The minimum requirement is the start and the end journey points. And again, if you can note these so we can check them, just to make sure that the costs are reasonable. And a failure to provide any correct evidence could result in a rejection or assessment. It's a delay to the costs that we're going to be able to pay you for such a simple sort of part of the process. First class travel, we are aware that some of the councils, especially the KCs or QCs as were, they do like to sometimes claim first class travel, but unless you can provide any documentary evidence to explain how it was more cost effective than standard class travel, you're not going to be able to get these processed. It's likely that you're going to have them either reduced to nil, or you're claiming the worst case scenario, the claim will be rejected. If council has claimed first class travel, I would recommend that you give us some sort of indication of how much a standard class travel would be for the same journey, and just give us some sort of idea as to what you're going to be able to be paid. Hotel costs are another thing which does cause a bit of an issue sometimes. These should really be claimed in line with the amounts noted in the electronic handbook. We've got them down there below. You can see some of the major towns and cities that we have in the UK, the 85, 25 and £100 for overnight stays. And again, elsewhere, it's generally 55, 25 and £65 for overnight stays after the 1st of September 23. We are aware that these are only guidelines, and there are instances where you're not going to be able to get any accommodation for those costs. So what we do again, we recommend is similar to the first class travel or travel generally, is just give us some alternative quotes, probably from something like booking.com or Trivago. Just let us know that you have been unable to secure any accommodation at any given day for those rates that we've got published there. I'll probably base the sort of recommendation. I'll probably base your quotes around the Premier Inn sort of Travelodge type hotels, sort of at the lower end. And if you can get one for under the £100 or the 65 or the 85 or the 55, then we're probably only going to be allowing that as a matter of course anyway. But it is a bit of a guideline and a bit of a conjecture, but if you give us enough information generally for travel and for hotel cost, then we should be able to at least process your bill rather than having to reject it as well, which again gets the money to council quicker and sort of saves everybody a bit of time. So I'll hand you back to Brian for the further slides that we've got left.
Right, thanks, John. As we've stated before, as high cost billing caseworkers, we pay other claims work streams as well, and one of the areas which we do see a few issues is inquests. So in inquest matters, council rates are applicable, and these are noted in Schedule 4 of the Civil Aid Remuneration Regulations 2013, and these fees are set out as below. So these are day rate fees and are payable for each hearing day of when you do inquest work. So only the relevant fixed fee can be claimed per piece of work, and hourly rates are not applicable to inquests. A conference before the initial inquest hearing can be claimed as a refresher fee. The conference should be in direct relevance to the provision of advocacy services, and it is expected that any conference would be within a week of the initial hearing. So where the time period is more than this, a narrative should be supplied to confirm the actual circumstances as to why the conference has taken place. So that's really all we want to cover in respect of inquest. So that is the end of the billing issues in respect of the webinar.